Money and Me on Your Money, only on Money FM 89.3.
Welcome to Money and Me. I'm Michelle Martin. Just yesterday, I was in conversation with Ms. Tin Pei Ling, MP for McPherson SMC, and we were discussing the 4 key amendments that have been made to the Maintenance of Parents Bill. Here's a recap of the 4 changes. Parents with records of abandonment, abuse, or neglect against their child must declare this to the tribunal and seek its permission to file maintenance claims. The president and deputy president of the Tribunal for the Maintenance of Parents will be empowered to dismiss frivolous or vexatious applications without informing or involving the child. The commissioner of the Maintenance of Parents is empowered to have the child attend conciliation sessions if there is no evidence that their parents were abusive, so they can hear the child's side of the story, discuss care arrangements for their destitute parents, and encourage or support them. The tribunal is empowered to make non-monetary directions, such as requiring the attendance of counseling sessions. We continue the conversation with part 2 of our series today. We've invited the tribunal president and commissioner for the Maintenance of Parents to analyze the significance of these changes and what's the thought processes behind these amendments, the first to happen since 2010. Mr. Gregory Vijayendran is tribunal president for Maintenance of Parents. Gregory, good morning.
Good morning.
Mr. Khoo is Commissioner for the Maintenance of Parents. Mr. Khoo, good morning and welcome.
Good morning, Michelle. It's a delight to be on this program.
Likewise. Mr. Khoo, maybe we could start with you. Can you give us a sense of how many parents in Singapore have had to rely on this piece of legislation for monetary support over the years?
Certainly. The Commissioner's Office commenced operation in mid-2010. The highest caseload we have registered would be in 2012, where we had 303 cases. Over the next 4 years, the cases went down and averaged about 200 per year. And in the last 6 years, the numbers have been in the hundreds.
So we're actually seeing less parents relying on this piece of legislation. I think that's good news. Gregory, help us understand how the amendments enhance the powers of the tribunal and why that was deemed necessary if less people are relying on this piece of law.
Thank you very much, Michelle, for giving me an opportunity to share. You summarized the amendments very neatly earlier. And just to unpack that slightly, the first of the amendments, which require parents with records of abandonment, abuse, or neglect against their child to first obtain the tribunal's permission before they proceed with their claim, introduces what I would call a filtration mechanism, because it has a tier which necessitates parents who have these records of ANA, abandonment, neglect, or abuse against their children to essentially satisfy the tribunal that it is a fit and proper case to proceed with their claim. And so that will weed out some cases that are unmeritorious. The second amendment, which empowers the tribunal to dismiss frivolous and vexatious applications without requiring the children to respond, confers on the tribunal summary dismissal powers, which allow the tribunal to take what I would term on child to even respond or to be involved, and in that sense protects them from the effects of distress that could be felt when a parent that has been, for example, their abuser decides to apply for maintenance against them, and essentially also strengthens the hand of the tribunal to ensure that only appropriate cases will be heard ultimately by the tribunal and will be the subject of fair hearing. The third amendment is quite self-explanatory. It empowers the commissioner to locate children of destitute parents for conciliation, and that is without the need for the parent to put in a formal application. And commissioner is, of course, well-placed and very knowledgeable about the work of the CMP and the outstanding way that it has resulted in conciliation. The Fourth Amendment empowers the tribunal to make non-monetary directions to address underlying issues between the parent and the child. So at present, we have binary options. We either grant the application or we dismiss it. And if we grant it, then of course there's a question of quantum. But with this amendment, which strengthens the hand of the tribunal, it allows for conditional orders where, for example, if a parent has a gambling addiction or may be vulnerable to scammers based on, for instance, the evidence that's before the tribunal, or may need some wisdom in terms of budgeting, some conditional orders can be made. And we've seen examples, particularly in context of gambling addiction, in which, for example, the children have been reluctant to give maintenance because they are afraid that the money will be frittered away on gambling addiction. And so those are, the amendments, in a sense, unpacked for you. And I'll just pause here.
Fantastic overview. Thank you for helping us, understand these amendments and what they mean for us. I want to maybe drill down a little bit on each one. So for the first amendment, which looks at protecting children who are abused, neglected, or abandoned from necessarily having to maintain their parents, where does the burden of providing the proof lie? And what constitutes a sufficient amount of proof of abuse? Gregory, would you be able to take that?
I will. And thank you for giving me a chance to, sort of delve deeper. The current regime, pre-amendment, required that the burden of proof, the onus of proof, is on the person alleging the abuse or the abandonment or the neglect. And so that means evidence needed to be produced by the respondent child to make good the claim that, there was a historical episode or episodes of such honor. Now, the beauty of the present amendment, and credit, needs to be given to the work group for very thoughtfully coming up with it, but essentially where there are records of this abandonment, abuse, or neglect, presumably, for example, from, either criminal records, personal protection orders, canned protection orders, or records from the MSF's Child and Adult Protective Services. So these would be official, it would be documentary, it would be largely the best evidence of, such abuse, neglect, or abandonment. Then the tribunal does not need to call the respondent to get that evidence, because the burden shifts, in a sense, to the parent to show the tribunal why it should have permission to proceed with their claims, despite having this record. Now, in some cases, they may be able to discharge that burden, cross that hurdle, and it may be just and equitable for leave to be granted, and then they will get a fair hearing, we'll hear both sides. But in some cases, they may not be able to cross that barrier.
I understand that the evidence that is furnished to the tribunal is not limited to official records. It can consist of oral or written recollections. Is that correct?
Yes, that is correct. And, that, of course, would be also, in some cases, given by the child, and it would be corroborated by other family members.
I wanted to understand how the tribunal or the commissioner ensures the credibility then of these historical recollections to build a case for abuse.
That's an excellent question, and it requires us to consider the matter forensically. So I mentioned best evidence because, where there is, for example, a personal protection order granted or a criminal conviction secured, that, would essentially establish the facts. That would be helpful, and likewise, some of the other official records. But as you rightly pointed out, Michelle, I think where there are going to be less than formal or perhaps even subjective recollections on the part of the abused victim, and I know it's painful, it's traumatic, it can be the subject of distress, there may be a risk of re-traumatization. And that's why, these amendments are, very strong. But where we see that, then we have to, of course, apply a very careful and, very analytical approach to that evidence. Is it corroborated? Does it have the credibility of truth? Can it be tested? And sometimes it's tested when, in the context of the crucible of the hearing, the parties are responding to each other. And so when you weigh it all together, is it in black and white, for example? Were there letters? In some cases, we've seen letters of psychological abuse on the part of the parent. And it's not just one-off episodic ad hoc, but, you can see a pattern. And so this is how we would then discern where the truth lies. Also, what does the parent have to say about it? Because in some cases, they have really nothing to say.
Right.
The truth is the truth.
Mr. Gregory Vijayendran is Tribunal President for Maintenance of Parents. Mr. Khoo Su is Commissioner. Mr. Khoo, can you weigh in and help us understand? This is a question maybe for the general public. What happens if children are not able to financially support their parents who have filed for maintenance orders? What happens then?
Well, the Maintenance of Parents Act specifically provides for various factors for the tribunal to consider. Now, at our level, we would have conciliation where we hear the versions of both parties, the elderly parent and the children. And I would say also that before that takes place, we would have background screening as to the resources of the children. So when we have come to the conclusion that the children have no resources or they have other commitments and they are not able to provide for the parents, what we do is that we will refer the elderly to other agencies for assistance. The law does not compel a child to support when he cannot.
Well said. The law does not compel a child to support when he or she cannot. Let's talk about destitute elderly in Singapore who do need support, who may have difficulty advocating for themselves. How do the key amendments address this issue? Destitute parents who maybe choose not to claim maintenance from their child for all sorts of fears. There could be all sorts of reasons, right? Fear of straining the relationship, estranged relationship, just not wanting to speak to their child for various reasons. How do the key amendments then empower the tribunal to advocate on behalf of these parents? Greg?
Yes, thank you. That's a good question. The key amendment and the inroad in this area is that previously we could not act unless the parents themselves come to apply or they give the consent to someone, call an agent, to come and apply on behalf. What this amendment does is that for various reasons, the parent doesn't want to apply or does not consent. The amendment allows and empowers the commissioner to go to the children, notwithstanding the fact that the parent is not consenting or is not claiming. And we have the power to invite them for mandatory conciliation. And that's where we have a good chat with the children to find out their versions and their circumstances.
Can a parent say, intervene in this process and say, I absolutely, these are my wishes. I do not wish to be brought into a conciliatory situation with my child. Is there room for the parent's voice?
No, at this stage, the parent is not involved, Michelle. We do not inform the parent what we are doing. We just want to have a chat with the children first. Because this is a case where oftentimes it's egregious, Michelle, where you have children who seemingly could afford and they are not forthcoming in supporting the children. So we really need to speak to these children and find out why are you not supporting the parents.
Do you envision a point, Mr. Khoo, where the commissioner can be empowered to apply for maintenance on behalf of destitute parents, even without their consent?
Yes, no. The amendment here is to reach out to the children to have conciliation. The question of applying on behalf does not arise. It is conciliation stage, and this conciliation with the children is mandatory.
Okay, important distinction there. So the key amendment allows the commissioner to make movements towards conciliation, not to claim maintenance from their children without the permission of parents. Is that correct?
Yes, that is correct.
All right. Here's a question for you, Gregory. How far, in your opinion, do the amendments go towards addressing the concerns of the very many focus groups, I imagine, who weighed in?
Thank you very much, Michelle. In my view, these are very thoughtful, balanced, and calibrated amendments, which, on the one hand, strengthen the provisions for needy parents who are neglected. And that's, of course, the raison d'etre for the legislation for the Maintenance of Parents Act. On the other hand, it also introduces sensible measures to prevent its misuse And these measures, which are counterbalances, take a trauma-informed approach. And with all that we know now, and as we continue to understand, how an abuse victim or abandoned victim or neglected victim, and we've seen evidence of this in terms of even the tribunal work, but when we see how their response is, and in some cases it isn't to fight, it's really freeze or flight, and they may just give in order to get out. And we need to remember that, against that sort of psychological reality and the sort of familial dynamics of the parents, these measures strike the right balance, in my view, because they essentially sort of achieve the goals in a holistic fashion, bearing in mind the extensive consultation that the work group did. It also allows, as far as the conditional orders, the non-monetary directions are concerned, the opportunity to give the tribunal a chance to sort of tailor-make bespoke creative solutions that are specific to that particular family in order to come up with the right solution, bearing in mind the problem. And the problems that we're seeing are actually far more complex these days. So, in the light of that, this is a welcome amendment, a welcome set of amendments overall.
If I could just probe a little, what are some of these bespoke arrangements, Gregory? Are we moving beyond gambling? Are we looking at sort of other forces that could be tearing a family apart that the amendments can allow for direction for?
Yes, good question. So I had gambling in mind because, for example, in one case, when a parent had filed a maintenance claim against a son, the mom had, a gambling addiction. The son, who had previously helped service the gambling debts, wanted the mom to attend counseling to deal with her gambling habits. So with this power that is given to the tribunal, it would allow the tribunal to require that the mom attend a counseling session as a condition to getting the maintenance. And that's a sensible way to deal with the root of the problem. Some other examples, and I sort of alluded to that earlier, would involve cases where a parent might be vulnerable to scammers, and so perhaps there may be a need for literacy on anti-scamming, or perhaps even wisdom in terms of budgeting financially, because it may be that some of the maintenance issues flow from a lack of sensible, prudent financial management. And that, Michelle, could be addressed through this non-monetary direction. So those were some of the examples, just drawing back from the tribunal's work.
Thank you so much for those key examples, Mr. Gregory Vijayendran. Mr. Khoo, I want to give you the final word as well. Same question for you that I put to Greg a while ago. How far do the amendments go towards addressing the concerns of the focus groups? Maybe you can weigh in from your perspective as Commissioner.
Yeah, the focus group had a few areas of concern, which have been crystallized in the 4 areas of amendments. But I think the inroad now is the approach where we can, under the amendments, help the destitutes. And this has been achieved by the amendments, where the commissioner is empowered, which he had no such power previously, to reach out to the children without the consent of the elderly, to call them up for mandatory conciliation. And this is a good amendment because then we have the opportunity to hear the children's version as to why they have the means but they are not. Is this a case of unwilling? And what other reason? Is because of abandonment, abuse, or neglect? So we feel that we need to give the children an opportunity to be heard. And if they have no valid reason, then they would have to support. If they still are not coming and supporting, then of course a commissioner would have to consider whether to lodge a claim on behalf of the destitute.
Well, hopefully these amendments help heal families as well, going beyond the monetary. Thank you so much, gentlemen, for joining us this morning. Mr. Gregory Vijayendran is Tribunal President. Mr. Khoo Un Soo is Commissioner. Gentlemen, thank you for your time.
Yeah, thank you,
Thank
Michelle.
you so much for having us, Michelle.
This is Money and Me. I'm Michelle. Stay with me. The news is next.
Before acting on the information on Money FM, Please consider if it's suitable for your own investment objectives.
Money FM 89.